breaking news coverage this hour as two major court hearings for Donald Trump were underway today. One over whether to disqualify the district attorney in Fulton County, Georgia, who has charged Trump and many others with trying to overturn the election there. The other, though, is in Florida on the classified documents case, where Trump's team is trying to get the trial delayed until after the 2024 election. Here to talk about that strategy is David Schoen, who represented Donald Trump in his second impeachment trial. And David, it's great to have you here because I want to understand something, and I'm a little confused by this. But basically, Trump's attorney here, Todd Blanche, one of the several here, was saying basically that a trial that takes place before the election is a mistake and should not happen. But then, just a few moments later, and overall in this documents case, they're also arguing that if it does happen, it must happen August 12th. Why that turnaround? How can they argue that it can't happen before the election, but then, oh, also here is a date where it could potentially happen?
Well, I think in this case, his main argument on August 12th is it can't happen July 6th or July 8th, and therefore an alternative would be August 12th. They need to have a date, first of all, I think procedurally, for Speedy Trial Act purposes. So they want to have a date on the calendar at least. But his overriding argument is they shouldn't have the trial before the election because considering the election is a factor that's relevant to the analysis here.
But the judge didn't really seem, Judge Cannon here, to want to hear the argument about how it coincides with the political calendar. I mean, she seemed to shoot that down as they were making their arguments.
I think you're right. I think she always has, frankly. Her position always has that, that may be a consideration, but that's not her consideration. She's in charge of the judicial process. And, look, I don't know what she thinks about it personally and so on, but I think she's trying to keep things really cabined into what's necessary for the case and to get the case ready for trial.
Todd Blanche was also arguing that they're not trying to play these court cases off of one another. At one point, he said that this is not a game, was his argument. But it seems very clearly that they are trying to play them off one another. At least they're trying to get the classified documents case scheduled later in the summer. So then if they do lose at the Supreme Court come June, it would jam Judge Schoen in Washington for the federal election subversion case. Does that not seem like a very clear strategy to you?
Well, I mean, I think there are two aspects to it. One could be seen as a strategy that one might say is gamesmanship. I don't think so in this case. I think there are a couple of things. Blanche is in both of those cases, by the way, the Florida case and the D.C. case. There's very different preparation for both cases. And President Trump is appearing. He's going to be in court in all of those cases. The other thing I think that ought to be spoken about here is there are a lot of pretrial issues to discuss that are very serious issues and complicated issues in this Florida case. The immunity thing that's applying in D.C. is still under review. It's going to be reviewed now by the Supreme Court. That's been raised in this case. There's the question of Evan Corcoran's records, which the Judge Howell in D.C. found were not privileged. There's going to be a question whether that tainted the grand jury process if a different judge now thinks that was wrong. And then they've raised, finally, in this case, the appointments clause issue. That is, that Jack Smith wasn't constitutionally appointed. These are complicated issues. They need time.
Yep. That last one seems maybe potentially far-fetched. But also at one point, Jay Bratt, who is the prosecutor for the special counsel, he was actually at Mar-a-Lago the day that it was raided. He said that a Justice Department policy that discourages public investigative actions 60 days before an election doesn't apply here because that applies to indictments or starting an investigation. But given Donald Trump was charged so long ago in this case, that's not relevant. Do you agree with that?
He's technically right. I don't think that it's right that it's not relevant. I think the same policy problems that arise with having the investigation within 60 days of the election are even amplified by having a trial. So I think he's technically right about the policy, but I think the policy ought to be applied to a trial.
And David, you're from the South. Let me ask you on what we were watching today happening in Georgia. Do you think the defense attorneys have met their burden in here in arguing that Fani Willis, the district attorney, should be disqualified, or do you think they weren't able to establish that?
Yeah, I'm not sure. First of all, I think one problem was I didn't see a lawyer in the courtroom who could ask a question during the course of this hearing. That was very frustrating to see. Only the judge seemed to be in control of things. But I think J. Tom Morgan is one of the most respected district attorneys we've had in Georgia. He's right that the case law requires an actual conflict. But I think what the prosecutor said today is very dangerous. He tried to explain why an appearance of bias or conflict doesn't apply. He said the prosecutor is always an advocate, therefore always has the appearance of bias. You'd never be able to have a criminal prosecution. That's absolutely absurd and dangerous. He needs to read a 1940 article by Justice Robert Jackson of the Supreme Court called The Federal Prosecutor that talks about the importance of a lack of bias. The American Bar Association standards on the prosecution function, 3-1.7. But the point is, there can be an actual conflict here. The actual conflict requires showing of an adverse impact or some actual prejudice to the proceeding, and that can be here. It doesn't matter when he was hired. He was hired before the grand jury met. And so did they have a motive for self-aggrandizement or financially to put some evidence before the grand jury to ensure a prosecution and hold off other? This may be theoretical. It may be realistic. The main thing to remember, I think, is the judge has an independent role in this. And while he may not be required to dismiss her based on an appearance of bias, he can. He has the authority because ultimately his role is to ensure the integrity of the process. That's why she should withdraw, as Norm Eisen has said.